Hi, my name is Alicia Kinchlow. I'm the owner and founder of Kinchlow Law. We're going to talk today about alimony. Before I get started, I want to remind you that this is not legal advice. This video is for informational purposes and that you should always consult an attorney in your area about the facts specific to your case. Now, with regard to alimony, we're going to talk about three different things today. The first thing is going to be the definition of alimony and how it's different from something called APL and spousal support. We're going to talk about some of the factors that the court must look at when deciding whether or not to award alimony. And then we're going to talk about some of the ways that alimony can end. So let's start with the definition of alimony. So the statute in Pennsylvania defines alimony as the support that is given after a divorce has been decreed by one spouse to a former spouse. Now, the thing about alimony is that generally it's a secondary remedy. The first remedy is the idea of equitable distribution of the marital assets. So alimony is supposed to step in where equitable distribution may fail or may not be able to put the parties in a reasonable position to care for themselves or to support themselves after the divorce. Now, there are a couple other ways of supporting someone when you're going through a divorce or a separation. Those two things are APL, which is alimony pendente lite, and then also spousal support. They differ from alimony in the main purpose being that alimony is after the divorce decree has been entered. Spousal support can take place before there's even a filing for divorce. So let's think of a situation where a person might be separated. One party has left the household and has left the other person to kind of fend for themselves. In that situation, there can be an entitlement to spousal support. Now, there are certain defenses that are allowable for not having to pay spousal support. There are a number of things that the court will consider, and the spousal support is determined by the guidelines. Spousal support is going to be talked about in another video on another day, but I just kind of want to put it out there so people can kind of get an idea of what is the difference between spousal support and alimony. The other one that I mentioned is APL, or alimony pendente lite, and kind of think of it as this: alimony pending the litigation. So this means that there has been a filing for divorce, but there has been no divorce decree, and one spouse needs some help or some support pending the litigation. Sometimes the amount of the APL can turn into the alimony award, but it has to be so ordered. So APL, it has a different set of factors. And again, that's going to be a video for another day. But what I just kind of want to put out there, just kind of have you thinking about the fact that there are other ways or other means of support besides alimony when it comes to the time period before the divorce decree has been entered. Now, speaking of when the divorce decree is entered, it's very important that one must kind of make sure that they asked for this type of economic relief in a divorce complaint or an answer or counter affidavit in divorce. If you don't assert this claim before the divorce decree is entered, then you could lose your rights to ask for any of those things after divorce goes into place. So you must at some point ask for that type of economic relief. Now, when considering whether or not to award alimony, the court looks at whether or not it's necessary. So it has to be necessary. And the court has, or the statute has laid out 17 factors. Now, we're not going to talk about all 17 of those factors today, but there are some main ones that kind of come up, and they're the ones that you would think about. The duration of the marriage. How long was the marriage? The earning capacities or abilities of the individual parties. What other property they may hold. What inheritances they might get. Some of the things that also come up is a situation where maybe one person or one party has put off kind of taking care of their own career, professional life, or ability to earn in order to support the other person. So those are some of the things the courts will consider. Now, the main question I would have to say, is about the duration of the marriage. The thing is that there is no set time frame for how long a marriage has to be before a court will award alimony. Some attorneys tend to think that it's, something less than 5 years may not be awardable. Some think that, 2 years might be the cutoff. It depends on all of those 17 factors. So where the duration of the marriage might be small, there might be another factor, maybe the health or the educational well-being of the other party, that's going to weigh a little bit more heavily. So don't think that just because it's a 2-year marriage or an 18-month marriage that there may not be an award of alimony. There could still be that. Now, it could affect or will affect and have some bearing on how long the alimony award is. So despite some popular belief, alimony does not necessarily have to last indefinitely. The court can make it a finite period of time or an indefinite period of time. And also the court can decide to make it based on some happening of some event. For example, if one person's going back to school and there's a set amount of time that the court expects them to be able to finish and may be able to get into another field and increase their earning capacity, they may make the alimony award terminable upon the completion of that event. So just kind of think about the fact that it doesn't have to be a set date or time, but it could be the completion of an event that would end up terminating the alimony award. Now, when it comes to deciding how much, same thing. The court's going to look at kind of what's been done with the equitable distribution of the assets, and they're going to look at the person's ability to earn, and they're going to also look at what's left over for the spouse who is responsible for paying. All of those things go into contemplation when determining the amount of the award. It's important to note, too, that an order by the court can also be modified. So this means that at any point in time, if there is a change in circumstances that a person can prove to be substantial and ongoing, either party can come back and ask for the award to be modified. You do have to prove those things that I just said, and the court will consider it, but you have to be able to prove those things. So we talked about the definition of alimony. We've talked about some of the factors the court will consider. And what I'm going to do too is link in the show notes the actual statute so you can see all 17 of the factors. The third thing we're going to talk about today are some ways that the alimony award can terminate. One of the main ways that an alimony award will terminate is upon the remarriage of the spouse who is receiving the alimony award. So if that person remarries, it will cease. And the statute says that specifically in 3706, that if they remarry, it will cease. What's important to note too is that if you come to an agreement in terms of alimony, and like in a settlement agreement, a marital settlement agreement, you can specify the terms that are going to govern the alimony award. But there are different sets of rules based on an award that a court gives, or there can be, in terms of enforceability, as well as what causes it to terminate. So you want to look very carefully at the way that you structure any agreement. You're going to also look at what the court is more likely to do when there's a change in circumstances, like the remarriage of the person who is receiving the alimony award. When it comes to the person who is paying the alimony award, that doesn't necessarily terminate the award. What it does instead is probably present a significant situation, like we discussed before, that would be a reason for the award to possibly be modified in some way. You still have to prove those things that I stated before, and you will come back to court and have to have a hearing or conference on whether or not those things exist and to what extent it should or should not affect the award. So those are just a few things about alimony that I feel people kind of need to know. And there's always a lot of cases, a lot of exceptions to the rules, a lot of ways the court has done things differently. But you want to kind of have an idea of the different types of support that's available to you, either as a person who needs to receive support or a person who's going to be responsible for paying it. And also remember that there are other forms of support outside of alimony. Again, spousal support and APL that will come into effect before even a divorce complaint has been filed or while the divorce is pending. Make sure that you subscribe to this channel to get more updates or more insight into things affecting custody, divorce, support, and estate planning. Until next time, take care.